Of Uhuru Kenyatta's election by the Supreme Court continues to elicit reaction from all corners, and even former governors. Candidates have taken to court their cases to court and to file petitions saying that their loss was not genuine. In studio, I have Mathare Member of Parliament Anthony Oloch and Senator for Nandi Samson Cherargei for the deeper understanding of what the promises and the avalanches of court cases that we expect. Welcome, gentlemen, and good to have you. Let's start first of all with the fact that just by virtue of the win by NASA for the annulment of the presidential election, we're already seeing the likes of governors and some members of parliament coming out to say that they will file a petition. Let me start with you, Mheshimiwa Anthony Oloch, on whether we should expect this to even increase as we go along.
Yes, thank you very much and good morning. It was expected, I think, that after the Supreme Court verdict annulling the election of Uhuru Kenyatta, that an avalanche of cases would be coming. I know for a fact that ODM and NASA, last night and the night before, there have been lots of work being done. The petitions that will be filed today, I know for sure that I will be filing one for Starehe Member of Parliament, the candidate Steve Mbogo under ODM. Lots of other petitions coming, and really, this comes in the wake of what I think is a paradigm shift by the Supreme Court. You see, in 2013, the narrative was created that apart from establishing that there are irregularities in an election or malpractices, you still needed to demonstrate that those irregularities affected the numbers. So there was this number equation. How does this change you from position 2 to 1? How does it turn the tables? Supreme Court 2017 has now focused more on what Maraga calls fidelity to the Constitution, to the processes, to the statutes and regulation. And really that's the starting point. And he said this, if I was to quote it, that the greatness of any nation lies with its fidelity to the Constitution, respect for the rule of law, and above all to God. Now what that says then is that you can invalidate an election by simply saying that this is what the Constitution says, these are the standards, these are the procedures. If the Constitution benchmarks would not have been established, then an election goes. You don't even have to go to the numbers. And this is what Article 2 says. We are in a constitutional democracy where the supremacy of the Constitution comes first. So anything that you do in the name of the Constitution that is contrary voids the election. And so a lot of MPs, senators, and governors will be coming to say, this narrative that Jubilee had X number of women reps and we had so many senators and so many MPs, therefore means we must have won the...
Questionable.
Yes, it is very questionable. And that brings us to what we are talking about, the computer-generated leaders. So you can understand why most of these leaders want to go and test and see. But I have to say that the Supreme Court judgment on its own will not help you. You still have to demonstrate your case, but it is an avenue for many of these leaders.
Samson Cherargei, you won, Nandi Senator. Are you a computer-generated leader?
I don't think so, because I won with over around 96% of the total vote. And therefore, I think when some people say they are faranga of computer, it means that is an insult to the ordinary voter, because I think under Article 38, the sanctity of a voter, what does it mean when you vote? Do you deny the voter the fact that they were administrative errors? So are we protecting the sanctity of the voter or the vote that you vote by the fact that a voter goes to a polling station and votes?
That would be a valid argument, assuming that the systems were followed, assuming the numbers that we have are genuine, assuming the numbers that we have now are real. But given the Supreme ruling, and we're waiting to hear what the full reason as to why they came up with that will come out, but given that they questioned, or the system that was was used, that it was not as transparent as it should be, the system that was supposed to be used was not used, then it is difficult to tell that those numbers are actually there. So really, the voter does not know how many people voted, how many votes were counted.
No, but in fact, that is another aspect, because when you look at the Elections Act, Section 83 of the Elections Act, is very clear. But you know that should apply in terms of qualitative and quantitative. So that is what the Supreme Court failed to look at. And the issue of numbers. It was not disputed in the Supreme Court. That is one interesting thing. So in as much as we are waiting for the next 21 days to look at the judgment, the issue did not tell us whether the administrative errors that might have been committed by the IBC affected the final result, and that is what we are yet to see. So the issue is, when these 15 million voters voted, does it mean if there are some errors? Because if you see the difference between the votes that the governors got and the voted for the presidency, it is around 43 votes different. And therefore, at the end of the day, when you look at all this, does it mean if there were some errors, does it mean you negate the will of 14 million voters? Because it means if a voter goes and votes, and then you don't mind about that vote, and you look at the procedure, and then it defeats why the reason as to many Kenyans woke up very early and voted for either NASA or Jubilee. And
all right. And let me come to you, Anthony. You are one of the lawyers who was representing NASA in the petition. And where does that leave 15 million voters? Because at the end of the day, yes, there is the question of whether those votes were tallied in a way that we cannot now tell who really won or who did not win or who got how many votes. But where does that leave 15 million voters that woke up very early that morning and went to vote?
Two things must be balanced. The argument has been advanced, and I heard this from senior counsels Ahmed Nasser, and advanced by the dissenting judges against the majority, that this is about the voter. And I hear my colleague here to be saying the same thing, that what happens to the person who voted? They advanced the argument that you can only overturn the elections if you can show that more people voted than should have voted, or a significant number of people who ought to have voted didn't vote. But that is based on this old school theory that we borrowed from the United Kingdom. It's based on the law of what they call the Morgan versus Simpson law, which is pegged partly on Section 83. But Section 83 is since bad law, because, you know, when you go by the principle of precedence, the Supreme Court sets precedent. And it has not only set a new precedent for Africa, I think it is third in the world to invalidate a presidential election of a sitting president. Section 83, which borrows from the UK Morgan versus Simpson, seems to focus on the idea that the end justifies the means. Howsoever you get that win, get the numbers, and then go back to Article 38 and say, what happens to the voter? But that has changed. That is now bad law. The Supreme Court has spoken and says the right to vote, and that voter is also underpinned by the universal suffrage principle that talks about one man, one vote.
Right.
And you know what that means? Is that 15 million votes count if, and I underline the word if, they were 15 million. It is possible that under the system that we now since know was manipulated, maybe it is 13 million. Maybe it is 14 million. It may very well be 17 million. Why do we think that it is 15 million? Let's go back to Raila Odinga 2013. And this is where the rain started beating us, so that we know why we're here. In 2013, Raila went to the Supreme Court, and the Supreme Court agreed with him, disagreed with him. They said three things. Number one, we didn't have a single voter of register. So they couldn't attack the presidential election then based on the multiple register. So in between, what happens? CORD, Raila and his team, they went back, they changed the law. We now have a single voter of registers, and that register is compiled electronically. The Supreme Court also says then that the voting system was manual, and they say that the whole idea that there was electronic voting was not in our laws. The CORD, Raila Odinga and his team, went back and changed the law Now we have electronic compilation of the register. You can get a register electronically. And the transmission of votes under Section 39 of the Election Act is in a prescribed form. And that's what we need to, when Maraga says respect for the rule of law, you cannot get to the numbers when the law says when the vote is tallied, counted, it must be transmitted electronically. We had 40,830-something polling stations.
Right.
Each had a KIMS kit. KIMS kit consolidated what you call the voter registration, voter identification, and results transmission. One gadget, one transaction. You cannot send text messages and stream them to some place on some screen and then you call them statistics. When the law says that text message, and go back to the Musando video, Musando took us step by step. What is KIMS? And he told us this thing has been certified. No text message can go without the image. And this is where the devil lies in the detail. They now bring the narrative that hatuwezi kusema ati kwamba kwa sababu form zingine 34 ziliitaflefiana, and he tells me this is not administrative errors. This is massive fraud on the people of Kenya, and I can tell you from authority. We got a ruling of the Supreme Court, go and open up the servers. And from the little that they allowed the petitioner to do, it shows that the chairman of the commission had multiple access and entry into the servers. Forms were being pulled. Form 34s were being uploaded 1 week, would you believe? 1 week before the elections and 10 days after the elections. That system cannot be right. You cannot call that administrative errors. So what we're here to tell you is that the Supreme Court has now spoken and has created a new law that you can invalidate a presidential election if you don't follow process. Election is a process. It is not an event.
Yes, I think I like my brother here said the Supreme Court has power to set its own president. And sometimes we expect surprises, and I think the Supreme Court set a political precedent, which we are yet to see. And then number two, when you see all these issues that they were raising, for example, it is good my colleague was part of the legal team of NASA. When you see they were quoting from the strongholds where the massive fraud was there. So there is a suspicion that most of the NASA strongholds supported the elections because they knew they didn't have numbers. And according to sources that we have is more than 5,000 from 34 A's and B's. The original was lost within the strongholds of NASA, and therefore it forced the IBC to photocopy, and that is where they build their case. So number three is that we have an Anthony Otiende case. I think when they sue Ministry of Lands, did not consult with National Land Commission, and therefore there were about 9,000 title deeds. But when we went into Supreme Court, the Supreme Court looked at the public interest, although those title deeds do not have watermarks. So the issue is the Supreme Court failed to be alive to the fact that there were so many issues of public interest that they needed to be alive in terms of presidential vote. And therefore, when all these, the issue, I don't all brief for IBC, of course, but when he raises these issues of saying there is massive fraud, that one does not add up because they never contested the numbers that we had. They went for invalidation. They questioned the process. So in the end of the day, when you see even NASA, when they were campaigning, they did not campaign as enthusiastically as because they were aware that they would support the entire process for the benefit, and that is why their lawyers were raising on issues of Form 34 A's and B's on whether it was written, unwritten, or whether it was originally or whatever. So all that shenaniganism that they brought and they roped in, they ensured that the Supreme Court made a political decision because Supreme Court sets only precedent.
All right, Samson, let me... assuming, and let's look at it now in terms of projecting the way forward, because that is water under the bridge. The Supreme Court has already ruled, and we cannot go back to court on that. But given the anomalies and the questions that were raised, which the Supreme Court has said they're going to give a report and a full breakdown as to why they came up with that particular ruling of the petition, isn't it good for a democracy, in your opinion, for us to be scrutinizing and looking at this system so that beyond any shadow of a doubt, If we go to the poll next time, which we are going to go on the 17th, then whoever comes out the winner, there is even no need to go to the Supreme Court, because the systems have been put in place to ensure there are checks and balances, that whoever is pronounced as the winner is clear right from the beginning. Isn't that a good thing?
I think it's a good thing, but you know, we have 21 days to look at the judgment, and IBC already has set a date to be 17 October. And I think some of these issues that the Supreme Court raised for the IBC, but one interesting thing in that directions that the Supreme Court gave is that they ordered IBC to do fresh election. But as the narrative that NASA normally builds, is they want to go to demonstration, remove IEBC, discredit Chebokati, discredit Jeloba. In fact, they are doing ethnic profiling. You saw the names that NASA principal, and we respect him as the father of democracy. You saw the red names that border to some ethnic profiling in IEBC, especially on the secretariat. So when you look at all those issues, we need to, when IEBC sets, and I think the NASA fraternity should respect the independent institutions. And therefore, when even Jubilee castigates or criticizes the Jubilee, the Supreme Court verdict, it doesn't mean that it did not. They have insisted that we respect the decision that the Supreme Court took. But we have a right to criticize. And I remember even sometimes back, and you know, I think we have selective amnesia on some of these issues. We remember back when the NASA principal went to court, and the court did not, they called them in Mahakama Bandia. So what does it, let us not have double standards, let us respect the institutions that had been set, and even the Supreme Court has ordered IEBC to do. So we expect IEBC, of course, I agree with you, we expect IEBC to be beyond suspicion, like the Caesar's wife, so that we have a proper, credible, transparent, as by the principles of elections that the Constitution are set out.
All right, we want to take a short break now, and of course we welcome you to participate in this conversation. You can do that via Twitter. And when we come back, I'd like to hear from you, Anthony Oluoch. And given that we still do not have the full reading of the Supreme Court, whether you feel IEBC is going to be adequately prepared, because some of the things that may need reform are possibly in that particular judgment that we do not have as yet. Yet the date has been set. So maybe we'll start off from there. This is Morning